Hello, good afternoon. My name is Halley Auger. I'm an employment lawyer and an associate with Samfiru Tumarkin out of the Calgary office. So I'm licensed to practice in Alberta. I'm here today to answer your questions live about any employment matters that you're facing. So you can ask your questions live on YouTube, Facebook, or LinkedIn, and we're going to answer them today. As we're getting started, we're going to chat a little bit about some exciting news. Well, at least it's exciting news for an Albertan. Canada's oil and gas sector has an all-time high since 2015 for employment in oil and gas. So we are seeing a resurgence of employment in that area. The good news is that for those who are looking for employment, there's plenty of opportunities. Now, you are going to be getting new employment contracts. There's certain things that people tend to look at when they get an employment contract. What am I doing? How much am I getting paid for it? What are my hours going to be? There's different things that employment lawyers look at. One of the things we particularly look at is what happens when your employment comes to an end. And so that's usually who's coming to us, somebody who's got a severance package and wants us to review it. One of the things we look at is their termination clause. So please feel free to reach out to our firm if you'd like to have your new employment contract reviewed, particularly for things that may come back to bite you at the end of your employment. Okay. So please log on, ask your questions. Hopefully you have things that you need urgently answered. Happy to provide you with some information. All right, we've got our first question from Soggy Mittens. My employer has said that we won't be taking new jobs at the end of this year because he wants to retire. We work in various provinces. How would that affect my severance? So what I think you're saying is your employer won't be taking on new work because he's looking to retire. So effectively, this would be a company shutting down. So if your employer wants to let you know that your employment is coming to an end at some day in the future, your employer has to provide you something called working notice. That is, you're receiving notice that at some point in the future, you'll have to be looking for new work. Now, your employer has to provide you with reasonable notice unless there's a term in your employment contract. And so how much notice you're entitled to is an individualistic exercise. It's based on your age, it's based on your length of service, it's based on the character of your employment, meaning what you do, how much you get paid, where you work, and availability of comparable jobs in the marketplace. So in most circumstances, if your employer is telling you today that you're going to be out of work in January, that's probably not enough notice for most of your employees. So what I'd ask for from your employer is something in writing, providing you with written notice that your employment is going to come to an end at some day in the future. Now, it's not good enough for an employer to say, at some time in the future. There has to be a certain date because that's the date you need to know that you're, looking to start new employment. And so if your employer's not doing that, that doesn't count as working notice. So make sure that you're getting something in writing. And then as soon as you get that in writing, please contact our firm. We'd be happy to review those packages for you. You can contact our firm at employmentlawyer.ca. You can email us at help@employmentlawyer.ca or call us at 1-855-821-5900. All right, we have another question from Ocean 2022 on YouTube. If an employee has a medical condition that prevents them from being on standby during sleeping hours, nights, but can work a normal 8 to 5 Monday through Friday schedule, can an employer force them on disability rather than accommodate their hours? An employer has an obligation to accommodate a disclosed disability to the point of undue hardship. What that means is your employer would have to show somehow that that they cannot accommodate your inability to work or be on standby during sleeping hours for some significant reason. It's not a minor inconvenience. It's not a scheduling issue. What essentially they have to prove is our business will not be able to operate if we have to accommodate you. It will be too expensive. For example, if somebody is saying, I need an elevator lift, and the cost of the elevator is $300,000, and this is a company that only profits 50 grand a year. That would be undue hardship for that company. But to be able to, make these sort of minor accommodations, it would be surprising that an employer wouldn't be able to accommodate that, because certainly there'd be multiple employees that should be able to do standby. So it doesn't sound like your employer is meeting their duty to accommodate you in this case. Now, if an employer has some good reason, maybe there's only 2 employees, and it wouldn't be fair to the other employee if that employee always had to be the one on standby. They could put you on disability. Thank goodness you have it. But I think they would still have to prove that undue hardship first. They have to provide some reason why they're not able to accommodate your medical request. People who have disabilities are entitled to participate in the workforce. They are entitled to the dignity that comes with being a productive member of society. And if minor accommodations are requested in order to meet that, your employer is statutorily obligated to try and do that for you, okay? All right, a question from Jen S. Oh, I'm just gonna turn that off. My friend is about 7 months pregnant and her employer let her go after reducing her hours twice. The first time she agreed, but did not the second time. Is she owed compensation? Oh, this is a great question, Jen. There's a lot of different legal issues going on. So the first issue let's talk about is whether your employer is allowed to reduce your work hours. Effectively, what your employer is doing is changing your employment relationship. Sometimes employers can do that. They can do it if you signed an employment contract that says that they're allowed to do it. If you didn't sign a contract that says they're allowed to do it, or if your contract is silent on that issue, the real question we look at is how big is the change? Employers are allowed to make reasonable changes to your work hours. And a reasonable change is, okay, we're cutting you from 40 hours to 37.5 hours a week. Now, if they're cutting your work hours more than 80%, so if you were working 40 hours and now they're trying to cut you down to 32 hours, that starts to be a substantial change. If you don't have a term in your contract that allows them to make that change, then you can say, I don't accept the change. You are trying to unilaterally and really substantially change our employment relationship. The ball is then in the employer's court. The employer gets to say, okay, fine, we'll leave you at 40 hours a week. Or the employer can say, we're instituting this change and you have to accept it. Now, you don't have to accept it. What you can do in that case is consider yourself to be what's called constructively dismissed. That means that in effect, you've been terminated from your employment because no reasonable person would be expected to continue under such changed circumstances. So in the case that Jen is pointing out, it's the first time she accepted the change. Now she doesn't want to because there's a big change. So if the change is big and it's substantial, it may be a constructive dismissal. The implication, obviously, is that we have somebody who is 7 months pregnant. And I'm assuming that person is going to try and go or wants to access their maternity leave benefits for EI. So we need to make sure that this employee isn't being treated in a way that now may deprive her from having enough banked hours to qualify for EI. And so she could be certainly facing some pretty big consequences and losing out maternity leave benefits if her employer is cutting her hours and she's not going to have enough banked by the time she goes on maternity leave. All right. And Jen has a little follow-up question saying, forgot to add that she has missed a bunch of work from being sick in her first trimester, but she was not told that was why she was being let go. I'm not sure if I'm understanding, Jen, because I didn't understand she was being let go. I thought you said they were just reducing her hours. Now, if an employer is letting her go or is penalizing her, either reducing her work hours because she missed a lot of work because she was pregnant, or is letting her go or reducing her hours, that certainly sounds like discrimination to me. Being pregnant is a protected ground under human rights legislation. So it means that an employer is not allowed to adversely, so negatively, treat you in any way in connection with you being pregnant, and certainly, having to miss days of work because of sicknesses that are associated with pregnancy. So, no, Jen, if your friend is being mistreated or treated as adversely because she took time off work for just being pregnant, that sounds like discrimination to me. Okay. Back to Soggy Mittens, she has said, it's been about 1 month of notice, I guess. I've worked there for 11 years, mainly work in BC, but our base operations is in Alberta. So no, Soggy Mittens, and no province, at least no province that I'm aware of, is that enough notice? So it's not enough notice for sure. Under Alberta legislation, you'd be entitled to 8 weeks minimum. Now that's a minimum, it's not a maximum, but there's a mandatory minimum amount of notice you must receive. In Alberta, for somebody who has 11 years of service, that would be 8 weeks. Whether in BC it's 8 weeks or it's 10 weeks, I'm not sure, but certainly it's not 1 month. So I do recommend that you reach out to our firm. Again, go to employmentlawyer.ca, call us at 1-855-821-5900. Speak with one of our intakes who can get you assigned to speak with one of our talented lawyers in the BC office. All right, Renee F. has a question. How long can a company drag out a lawsuit that they know they will lose? It's a misclassification of independent contractor case. They terminated workers with no severance at all after 15 years. So there's an old saying that says the wheels of justice turn slowly. I don't know what province Renee is in, but Alberta's not too bad, but there are certainly judicial backlogs through every province. Our justice system is a little funny. It's kind of designed so that you don't access it. In saying that, I mean that courts really encourage people to try and resolve lawsuits on their own without needing to access precious court resources. It's a very typical strategy for employers to drag out cases. They have no benefit for resolving a matter quickly. And so one of the best things that you can do is hire a qualified employment lawyer who can move your matter forward quickly, create that pressure and that leverage to try and show the employer, hey, the writing is on the wall, you're not going to win this. There's a lot of benefit to resolving this matter amicably and early. And we may even give you a little discount on what the ultimate award is going to be if you agree to settle it early. And so certainly reach out to our firm if we're not already your lawyers about how you can use a lawyer to move your matter forward in a quick way to create leverage to extract great settlements. All right. We've got a message from Dita Lynn. It says, my sister just found out that her employer is eliminating her position while she's on maternity leave. Can they just do that? Is it discrimination? So, sorry, Bubbles Bubbles the Woodle has decided to make an appearance. All right, so if that's a complicated question, Dita, because well, first of all, I'm not sure if your friend is a federally regulated employee. Most people are not federally regulated employees. They're regulated by provincial legislation. But if they're working for a bank or in the aviation industry or in transportation, she may be a federally regulated employee. And the question really is, are they truly eliminating her position? Or have they been able to eliminate her position because they redelegated her duties while she was on maternity leave? Those are kind of different things. Eliminating a position is when an employer closes a business unit. We used to be in the business of snow removal, and we're no longer in snow removal, so we have to let go of all of our snow removal people. That's truly the elimination of a position. But the elimination of a position is, oh, well, because you went on maternity leave, we hired this young person who's going to work for a lower hourly rate and we've delegated your duties. So your position is eliminated, but this new position has been created that you are perfectly qualified for. Yes, that's discrimination. Maternity leave is job protected leave. It means that your employer has to return you to your position or a comparable position upon your return. The exception to that rule is when there truly is the elimination of the position or a closure of a business unit or a closure of the company. In that case, your termination isn't connected to your status as a pregnant person or a person on maternity leave. It's in connection with a business operational issue. So not necessarily discrimination. However, your sister is entitled to severance in that case. And because she has terminated on, she'll be facing a termination technically upon the return of a maternity leave where she's just been using EI maternity leave benefits, she may now not qualify for EI regular benefits. And so that should be taken into consideration by the employer when they're making a severance offer to your sister. Okay. Next question. Crash into two. Working for an American company remotely as a call agent, they have said that our employment contracts are set up for at-will employment, so no severance. Does that hold up in Canada? No. So what at-will employment means is an employer can terminate you at any time for any reason with no notice and no pay in lieu of notice. We don't have at-will employment in Canada. There is a mandatory obligation that if your employer lets you go, they must provide you with notice or pay in lieu of notice that your employment is coming to an end. So even though your American company has their head office in America, we've created a set of rules that deal with what jurisdiction applies. Jurisdiction means, where would the lawsuit begin? And the way the system has been designed is the laws that apply to you are the place where you perform your work. So if you are performing work in Alberta and your employer is in Ontario or California, you're still an Alberta employee. You're entitled to Alberta protections under our legislation. So crash into two. It doesn't matter what your employment contract says. It doesn't matter what your employer is trying to say. They cannot terminate you without pay or severance or notice, okay? That's the tricky thing about employment contracts, people. Just because your contract says something doesn't mean it's true. The example we always learned about in law school is you can't have a contract with somebody that says they can come and murder you. That would be an illegal contract. There's a lot of things that people put in employment contracts that look enforceable, but really aren't. So whether it's because it's for another province or whether it's something that they found on ChatGPT, most frequently, terms in employment contracts that try and take rights away from employees are not enforceable. So make sure you have an employment lawyer look at them. Okay. A question on YouTube from Smarty Artie. If you have a verbal agreement with your employer about a raise and they later claim it didn't happen, what kind of options do you have? Well, there is certainly ways that we can deal with it. Verbal agreements are agreements and they are enforceable. The question really becomes about how long ago the raise was promised. So if your employer said back in December of 2023, they promised a raise, but then maybe 2024 went by and there was no raise, you're going to be in a little bit of a pickle. It's not impossible, but it's going to be a little bit harder to prove because you're going to be asked, well, why did you continue to work without the raise? So you certainly will need to have some explanation for it. Now, lawyers like me exist because one person says X and one person says Y. That's why there's courts. That's why there's, mediators. That's why there's arbitrators. Just because you think that you can't prove the contract exists doesn't mean that it can't be proven through corroborating evidence. So for example, if you talk to your boss and your boss says, yeah, I'll give you a raise. And then you go out with your buddies that night to the pub and you're saying, my boss told me he's going to give me a raise. I'm so excited. Well, those people are now kind of witnesses, contemporaneous witnesses that you did have a conversation with your boss because you went and reported it. So that's an example that you can get around the he said, she said situation. The other thing about it is keep in mind that in a lawsuit, there's risk on both sides. You may have risk that you wouldn't be successful in proving that the raise was promised. They might be successful in establishing that there was no promise. But when it's kind of a up and down, that's actually a really good way to sort of meet in the middle and work through it as a settlement. So, don't hesitate to reach out to a competent and qualified employment lawyer to help you negotiate that situation, okay? Certainly, we're happy to help. Contact us at employmentlawyer.ca or at 1-855-821-5900. Okay, next question from Graham S. My wife has been on medical leave for a few months to recover from surgery. Her doctor had to extend the leave to February, and her employer terminated her after finding out. What should she do? Well, certainly call a lawyer. That sounds like complete discrimination. There is no set period of time that an employer is then allowed to terminate you. The whole point is to give you a leave from work so that you can focus on your recovery of health. And then when you are fit to return to work and you're cleared by a doctor, you can get back to work. The employer is not allowed to terminate you. You are still on job protected leave. Medical leave is job protected leave under the Employment Standards Code. There's a bunch of different options that your wife has. Certainly she has a claim for severance. Sounds like she may even have a claim for human rights damages because it does sound like discrimination. So I don't know what that employer is doing, but honestly, if employers behaved properly and legally and ethically and morally all the time, I'd be out of a job. And Bubbles would have no toys and no soft blanket and couch to sleep on. So, all right. Huggo Cutie. Hello, there is an existing demand letter that was sent by an employer to my previous employer, and right now it's giving me anxiety. Anyway, would it be wise to ignore a demand letter? There is an existing demand letter that was sent by an employer to my previous employer, and right now it's giving me anxiety. Anyway, would it be wise to ignore a demand letter? I'm not sure if there's a typo in there, but maybe there was an existing demand letter that was sent by a lawyer to your previous employer. So what a demand letter is that's a letter that usually sets out what you're saying that your legal entitlements are and why you believe you are entitled to them, and then provides an offer saying, I would like to receive X amount of dollars, and in exchange, I will sign a release that I won't file a lawsuit or any other claims against you. That's pretty typical. That's what we do. That's our bread and butter. Would it be wise to ignore a demand letter? No, it wouldn't be wise. Unless you think the employee is not going to do anything further, but if they've hired a lawyer to issue a demand letter, you have our assurance that if you don't respond to our demand letter, we're going to take next steps. And often that means filing a lawsuit. So no, it wouldn't be wise. I don't get ignored very often. Maybe that's just because I make it very hard to ignore me. But no, they don't get ignored that often. And when they do, certainly lawyers have tricks up their sleeve. We become annoying, but we also just file a lawsuit. So no, it wouldn't be wise to ignore a demand letter. Now, it's not necessarily that the employer is ignoring it. You think about what happens when an employer gets a demand letter, from a lawyer like myself, and they're going to Google me and say, oh gosh, that girl's got 10 years of experience being an employment lawyer. I better do something about this letter. They're going to be calling around trying to get their own lawyer involved. And sometimes that can take a little time. That lawyer might be providing them some legal advice, or that lawyer might be stepping in and saying, I will represent you. I just need some time to get retained, which means hired, and then get a responding letter out. So don't be too worried that they're ignoring the letter, especially if it was sent out by a lawyer, especially one of our lawyers, because we don't get ignored. Okay. JX2 says, if a coworker has been caught stealing but not dismissed, does the employer have any obligation to replace the possessions of others in the event more theft occurs by the same person or by others? What I think you're asking is, if there's a known thief or theft issue and the employer is taking steps that allow it to happen because they're not preventing it, do you have recourse against the employer? Maybe, and I know lawyers say maybe a lot, but there's a lot of factual circumstances that turn on it. It's under a concept called vicarious liability. That's when an employer is responsible for certain acts or omissions, which is a failure to act by its employees. A lot has to do with how the circumstances were set up that would allow theft to happen. Now, if an employer sets up lockers where people have their personal belongings, and the thief at the workplace is physically breaking into those lockers, well, the employer has taken steps to make sure that thefts don't happen. And they're not an insurer or a guarantor that you're never going to have your belongings stolen from. Now, if there's a known thief and the employer's not taken any steps to prevent it, no lockers, they haven't gotten rid of that employee or made that employee pay for the stolen items, yeah, potentially. But certainly there's a lot of facts that can change the answer to that question, Jay. All right, Amar. A big corporation employer can deny to reinstate your employment of 19 years, even if they are not able to prove the cause of terminating your employment under human rights and employment law. So reinstatement is a bit unique. An employer, unless you are a unionized worker, or even if you're a federally regulated employee, so if you work for one of the banks or the airlines or whatever, an employer is allowed to terminate you, pretty much at any time, unless you're on job protected leave, pretty much for any reason, unless it's discriminatory. And the only obligation to you is to provide you with either working notice or pay in lieu of notice. You don't have, if you're not a unionized worker, you don't have a guarantee of continued employment. Reinstatement does happen in a couple of cases. So if your employer has terminated you as a result of discrimination, If your employer has terminated you in connection with you raising a safety issue, or like a refusal to work, or making a safety complaint, then there are tribunals, the Human Rights Tribunal or Occupational Health and Safety, that can order reinstatement with back pay. So there are certain situations where reinstatement applies. Now, reinstatement is one of the things that the tribunal can do. It's not necessarily the thing that they will do, but certainly they have the ability to do it. So can the big corporation employer deny to reinstate you? It depends if somebody has ordered reinstatement, and by somebody I mean a tribunal of competent jurisdiction. If you are just asking for reinstatement because they're saying they terminated you for cause, and you say, well, I didn't do it, I want my job back, in most cases, they have no obligation to return you to work. Now, you can certainly sue them for severance, and that could be up to 24 months if you've been there for 19 years. So they owe you something, whether it's reinstatement or severance. Certainly reach out to one of our employment lawyers. So contact our intake team at the employmentlawyer.ca website, email us at help@employmentlawyer.ca, or call us at 1-855-821-5900. All right. So we are done for today. That's the half hour that we have for today. Thanks so much, everyone who attended for my first live stream. I enjoyed being with you guys today. I really thought the questions were really interesting, and I'd be happy to come back and host one of these again.